Our guest today is the Executive Director of the American Civil Liberties Union of Illinois. She is the first woman attorney to lead the American Civil Liberties Union of Illinois. And there are more than 70,000, 000, ACLU members in Illinois. That's what I say. Yes. She is a native of North Dakota who graduated from North Dakota State University and the University of Iowa Law School. Ladies and gentlemen, Colleen Connell. Colleen? Yeah. All right.
Good afternoon. Jay, thank you for that always gracious introduction. And Father Ryan, thank you for such an inspiring invocation. I appreciated the kind words about the ACLU and speaking for many who don't have a voice. And I'm going to tag on to your closing sentiments about hoping that the golden gates of America stay open. The ACLU really sees a large part of our job as speaking for the vulnerable and really keeping the golden opportunities that the Constitution promises available for all of us. And really, I think that is probably the appropriate introduction into my remarks. It's probably not an accident that this is the third time I've been invited to address the City Club since the 2016 election. And I think it's, quite frankly, because the ACLU really is identified nationwide as speaking for the vulnerable and the voiceless and for keeping those gates open. To state the obvious, it has been another troubling year since I was here a year ago in August. This administration has continued its unrelenting attacks on immigrants. It has continued to hold immigrant children in cages despite a court order directing an end to this hideous practice. It has limited access to the desperate people who seek asylum in this country. And it has attempted to revoke medical deferments that would force the deportation of thousands of seriously ill people. Its outrages are not limited to people who are immigrants. It has continued its efforts to suppress the vote, and it has tried desperately hard to limit an accurate census, particularly counting among people of color. And unfortunately, it has spurred yet another race to get the Supreme Court, now stacked with two Trump appointees who are hostile to reproductive rights, to overrule Roe versus Wade. The few policies that I've just ticked off share more than their visceral cruelty. They are linked to a goal of rewriting our current legal framework to ensure the primacy of white, particularly and predominantly Christian men. Lest you think I've been spending too much time reading dystopian novels like The Handmaid's Tale and its sequel, The Testaments, both history and current events document the symbiosis linking the crude white supremacists on the streets and many of the lawyers who call themselves constitutional originalists, smugly suggesting that they have a monopoly on defending the true and permanent meaning of our Constitution. Today I want to talk about abortion rights and what they mean to our democracy. I submit that abortion rights must be viewed as the legal equivalent of the proverbial canary in the constitutional coal mine. Unraveling protection for abortion rights puts at risk the entire spectrum of rights for women, LGBTQ people, people of color, and people who adhere to faiths other than Christianity. The attacks on abortion rights reveal a fundamental unwillingness to treat women as full moral and legal people entitled to enjoy the same protection of the law enjoyed by men. That is the ineffable conclusion of allowing concern for the nascent fetus to override the rights of women. And I submit, it is a similar unwillingness to recognize LGBTQ people, people of color, immigrants, and people who practice minority religions as equals deserving the full protection of the rule of law. And it is that conclusion that undergirds the white supremacists and the white nationalists that have surged since the 2016 election. Let me start by examining closely what white supremacists say about reproductive rights. F. Roger Devlin, a longtime white nationalist, puts it bluntly, and I quote, "Women's liberation has actively hurt white men's ability to procreate because when white women have choices, they are less likely to get married, have children, and perpetuate the right race." Let that sink in. When women have choices, then the white race suffers. Their inexorable conclusion, therefore, is to eliminate women's rights, including reproductive rights. A deeper look shows that this hostility to reproductive freedom reinforces the so-called replacement ideology of white supremacists, namely that low birth rates among white women facilitate the white people's replacement by people of color. Interspersed in many of these writings is also deep anti-Semitism and concerns about preserving our Christian nation. Likewise, the homophobia of many in the alt-right expresses their hatred through falling white birth rates and fear of replacement. The chants of "you will not replace us" in white nationalist marches, and that permeate the rants of those who attack synagogues in Pittsburgh and Poway, California, are haunting echoes of earlier times. Now, it is tempting to marginalize these hateful ideologies as the rants of those who fear America's changing demographics. However, it is important to understand that the threat posed by these ideologies is much more serious because of how they intersect with a quieter but much more sophisticated movement. A movement of those seeking a reactionary rewriting of our constitutional and statutory doctrines that ignores more than 2 centuries of progress, constitutional amendment, and other legal developments. Often, these arguments are couched in terms of respect for the original intent of the framers. I want to examine Roe and the attacks on the constitutional doctrines underlying Roe as a way to further explicate this connection. Roe versus Wade is best understood not as a single decision, but as part of the legacy of what historians call the second founding of the United States. This second founding revolves largely around the ratification of the 13th, 14th, and 15th Amendments to the Constitution. These Civil War amendments, as you know, abolished slavery, explicitly recognized birthright citizenship, established the right of men of color to vote, and explicitly enshrined the concepts of due process and equal protection of the law for every person. That was the language used into our Constitution. Roe, from this perspective, reflects the robust culmination of the two constitutional doctrines of due process and equal protection of the law, to go all lawyerly on you, that have helped to extend the Constitution's original promises to all Americans, not just the white men of property, who were the framers and the beneficiaries of our original Constitution. To be clear, the broad vision of liberty articulated in the Roe decision was not conceived by the Supreme Court in 1973. Prior to Roe, the right of straight men to make and implement personal decisions about whether to marry or to seek or refuse medical care were so intrinsic, so fundamental to any concept of liberty, that no one thought it necessary to specifically protect those rights in the explicit text of the Constitution. Roe's legacy is that it extended to women the fundamental but unenumerated liberty to make our own decisions about fundamentally personal matters. In the wake of Roe, successive generations of federal and state jurists have understood that any meaningful concept of due process of law requires a rough parity between the treatment of men and the treatment of women in the conceptualization of liberty. That parity demands that the law must afford women, as well as men, the liberty to make decisions about our own bodies. As Steve Chapman recently wrote so eloquently in the Chicago Tribune, 13 people die every day awaiting kidney transplants. We could prevent those deaths by requiring kidney donations from anyone who is a donor match. But we don't. That's not because we don't value those whose lives would be saved by compelled organ donations. It's because we put a higher value on the personal freedom and bodily integrity of those who would be compelled to save them. In short, if the law cannot compel a man to donate a kidney to save his ailing child, the law should not be used to compel a woman to carry to term a pregnancy she wants to end. To force women to continue a pregnancy is not an affirmation of life, Steve continued. It is a denial of the humanity of women that should not, must not be permitted by our law. Let me repeat that. It is a denial of the humanity of women that should not, must not be repeated or permitted by our law. Roe, to state the obvious, did not permit the law to deny the humanity of women. Throughout the years, Roe has come to represent more than abortion rights, more than women's rights. It has become emblematic of a constitution that embraces and protects the most fundamental and intimate of human decisions, and the right of each of us to make those decisions, whether we are female, African American, gay, lesbian, bisexual, or transgender, a teen seeking an abortion that her parents oppose, or an older person contemplating end-of-life medical care or the rejection thereof. This protection of individual liberty, substantive due process, again to go all lawyerly on you, intersects and reinforces our commitment to equal protection and equal treatment under the law, regardless of the race, gender, sexual orientation, gender identity, nationality, or religion of the person at issue. In short, Roe embodies a more inclusive constitutional construct that protects people like me and people like so many of us here today. We are no longer invisible, no longer irrelevant under the eyes of our Constitution. So the renewed attacks on Roe must really be seen for what they are, an all-out campaign to turn back the clock to a less inclusive, less tolerant time. It's important to see that the attacks on Roe and its progeny are not limited to attacking constitutional protections against governmental overreach. Also at risk of contraction is the constitutionally granted power of Congress to pass civil rights legislation for the common good. Sections 5 of the 14th Amendment and Section 2 of the 15th Amendment specifically granted to Congress the power to define the meaning of the ethereal constitutional phrases of due process and equal protection of law. These amendments gave Congress the power to provide mechanisms to protect these rights, again, not just against government overreach, but also potentially against corporations and private persons who discriminate and deny others their rights. Unfortunately, The Supreme Court in the 19th century gave short shrift to those grants of congressional power and substantially limited the scope of the first Civil Rights Act. A century later, shamed by the hatred rained upon African Americans who sought a seat on the bus, a desk in a school, a room at the inn, Congress tried again. In passing the Civil Rights Act of 1964 and the Voting Rights Act of 1965, Congress once again asserted its constitutionally granted authority to pass laws for the common good, laws that affirmatively protected people of color and others eliminated or not seen in the original version of our Constitution, including women, including protection against private discrimination. These new civil rights laws also were attacked in the courts, but survived, at least at first. Unfortunately, we may be at the cusp of another era of contracting Congress's power to legislate for the common good. Many of the cases now working their way through the federal courts seek to limit the scope of Congress's power under the 14th Amendment and the 15th Amendment, as well as Congress's specifically enumerated power, again to legislate for the common good, that's found in the Commerce Clause, the Spending Clause, and the Taxing Clause. Just a few years ago, we saw the Supreme Court limit Congress's power under the 15th Amendment to protect voting rights. In the court's Shelby County decision, the court gutted the the Voting Rights Act of 1965. The court opined that there was insufficient evidence of discrimination against black voters to support Congress's power under the 15th Amendment to require southern states to pre-clear changes in their voting laws with the U.S. Department of Justice. At risk in the Supreme Court this term is Congress's use of the Commerce Clause, and at least derivatively its power under the 14th Amendment, to pass the broad protections of the Civil Rights Act of 1964. There are 3 cases in front of the court this term, 2 of which are ACLU cases, that test whether Title VII of the 64 Civil Rights Act protects gay people and transgender people from discrimination by their employers. Embedded in the technical arguments about the scope of congressional authority and what Congress really intended to protect in Title VII are insidious suggestions that gay people, transgender people, are not deserving of the full protection of the law, that our transgender client is not a real woman. Our client, Amy Stevens, was fired from her long-term job at a funeral home merely because she came to work presenting as the woman she is. Although these are recent cases that are working their way through the courts, the arguments that essentially claim that the law does not protect people who are different, people who are not white, people who are not cisgender, people who are not male, are not new. The ACLU and our allies have fought long and hard against these same old arguments in our effort to protect the broad scope of the civil rights and the voting rights laws. Over the years, we have won many challenges against more subtle forms of voter suppression, and we have won battles extending the civil rights laws to protect all people. But all of these gains are at risk, threatened by the same organizations and the same forces attacking Roe. As the Supreme Court has grown more conservative in recent years, it has become more sympathetic to white plaintiffs complaining that reverse discrimination is more of a problem than is continued discriminations of blacks seeking to overcome the legacies of enslavement in both the old and the new versions of Jim Crow. Some of the justices on the court view racial classifications, as in the protections provided in Title VII, not racial inequality, as the root of the country's race problems. They therefore oppose all race-conscious efforts to promote equality in education, employment, voting, and other realms. To resist these efforts to write white supremacy back into our laws and into our Constitution, we must see these threats as connected, and we must fight an integrated fight that seeks to protect the rights of all of us. An integrated strategy does not mean that we abandon our courts. To the contrary, we must redouble our efforts in our federal courts, challenging abuses and a cramped interpretation of our constitutional values whenever and wherever they occur. But our state courts must play a role as well. Recall that the federal Constitution is a floor beneath which no governmental entity can sink, but it is not the ceiling or the limit on protecting rights. In many states, including Illinois, a more modern written constitution contains expanded and extensive protections of basic rights that are not enumerated in the federal Constitution. The Kansas Supreme Court, for example, recently struck down a ban on abortion based on the state constitution, rather than relying on Roe or federal holdings. We too can utilize the state constitutional principles in many areas, and we are. And of course, we must also employ our efforts in the legislature. The ACLU and our allies have been fighting for many years in Springfield to protect basic rights. The results include enacting one of the most expansive and most protective human rights acts in the nation, a state civil rights act that combats rampant discrimination, and privacy protections that are keeping pace with modern technology. Last session, we took a giant step forward on abortion rights with the enactment of the Reproductive Health Act. The Reproductive Health Act declares that reproductive health care, including the decision to continue or terminate a pregnancy, is a fundamental right in the state of Illinois. The Reproductive Health Act became law because of the signature of a new governor who embraced the agenda and policy. But it got to the governor's desk because of strong support in the House and the Senate from incredible sponsors, from the majority leader and the Speaker of the Illinois House of Representatives, and a remarkable class of freshman House members who made the Reproductive Health Act one of their top priorities. And it got signed because of the efforts of so many people in this room and our members and our supporters, not just of the ACLU, but of our allies across the state of Illinois. We must take this victory as a lodestar to the creed that we must never lose sight of the fact that our work to protect basic rights, our work to fight white supremacy, our work to combat the narrow originalist view of the Constitution is vested in us. It's vested in we, the people. We must not be afraid to engage Americans in this work, to draw on their basic fairness and decency, and to make them see the consequences of policy, not just on themselves, not just today or tomorrow, but the consequences on the type of society we are leaving for our children. It is a sad truth that in 2016, many Americans stayed home from the polls with the attitude that their votes did not matter, that those who held office did not matter for themselves or for others. We see the consequences now of this view. And so we must work to engage those Americans and rally them and others to our cause and use every lever we have, particularly today, Constitution Day, to remember and to rededicate ourselves to the constitutional purpose of a more perfect union that secures justice for all. Thank you very much. Nobody has it. Come on up here, co-counsel. I know you're a lawyer. Come on. I welcome co-counsel. Come on in, Matt.
Yeah. Good afternoon, everybody. I'm Matt Martin, the new alderman in the 47th Ward. Thank you. and among other things, have the distinct pleasure of asking you some great questions from our audience. So I obviously am not Ed Mazer, so please bear with me as I share less wit than he does with you all. But I will start off with a question from a member, Martha Jantho, which is, there is a national effort to rewrite the federal Constitution. Only 6 more states, however, are needed to create a constitutional convention to do so. How likely is this to occur, in your opinion?
My opinion or my nightmares? The quick answer is I don't know. Many of the sources I read suggest that getting to those other 6 states is unlikely. But I think that we can't count on that, and I think that we need to be deliberate and strategic and to push back against a comprehensive constitution that, given sort of the composition of the amendment structure, could put many of the rights that I've talked about today at risk. One of the more sort of frightening, tidbits that I suspect we've all read is that, various public opinion polls, depending on when and where they're taken, suggest that substantial numbers of Americans would not, if put to the vote, basically vote for the essential components of the Bill of Rights that are contained in the U.S. Constitution. So I think that sort of reinforces the need for all of us, and I know I'm preaching to the choir in this room, to take seriously not just our constitutional rights, but our civic obligations to be activists and to vote.
Question number 2, pre-submitted from Jean Freed, a member of the Caucus of Rank-and-File Educators Corps, City Club member. We have a president who seeks to gain in the polls by exploiting prejudice and ignorance. How can we make a dent in this space? I'm going to give a shout out to the City Club. Participating in the great educational programs that the City Club makes available is necessary but not sufficient. And then I'm going to go back to one of the time-honored ACLU phrases about the importance of eternal vigilance. And I think that we have to push back against this ignorance every day, all the time, 24/7, 365 days a year. That does not make me a particularly lovely person to be married to at this point in time. My husband on occasion says, "Can we talk about something else?" No. But I think it underscores the seriousness, really, quite frankly, of the threat. And I think part of responding to that threat is to continue to push back against the framing that both embodies that ignorance and really pushes forth, the agenda of, sort of contracting rights for so many of the people in this room. Next question, and so my apologies, Martha, for not giving you a personal shout out the way I know Ed always does, but hopefully I can remedy that this time around. Jim Turman asked, what is ACLU's position on the right to bear arms, gun violence more generally, and Jim, where are you? Great.
So the ACLU position on the Second Amendment is that the Supreme Court basically got it right in its pre-Heller jurisprudence, in which the court had really looked at the Second Amendment in the context of the historical facts surrounding it, and actually the language of the Constitution, which talks about, a militia, and a state militia, really, at that. I think that the connection with gun violence is and crime is, very real and a big problem for society. But this is where I want to come back and really focus on the fact that guns and the lax gun laws in this society are a big part of the problem, and we should continue to resist the temptation
to revert to our former policies with respect to no bond, and our policies of really locking up people for a long, long period of time, because those problems, or excuse me, those solutions actually did not really solve the problem, and were significant contributors to what Michelle Alexander has rightly termed the new Jim Crow, where literally millions of people, particularly men of color, are locked up because of crimes that may have been committed or with guns. So I think that it's a very serious issue. I think that some of the advocacy that's going on to hopefully go back at and get a more reasoned construct of the Second Amendment is advisable.
Another question that was submitted online by Kevin Dixler, also a City Club member. How does the ACLU in Chicago interface with Lee Gallant, among other Chicago organizations, on immigration matters that have a national impact?
So Lee Gallant is a lawyer at the ACLU's national office in the Immigration Rights Project. And this is where I'm going to say the ACLU is a nationwide organization, and it is really a privilege to work for an organization that has both an overarching national strategy on how to challenge some of these issues and a great sensitivity for the facts on the ground, including the facts on the ground here in Illinois. How we interface with other immigration groups is, again, a really important question, and reflects really, I think, the ACLU's valued partnership with so many organizations, and that we really need to think about these issues and be good allies and work collaboratively to try to challenge the excesses that I identified at the first part of my speech by the Trump administration and the attacks on immigrants. More specificity would probably consume the rest of the hour, given the number of really terrific immigrant rights groups that are here in the city of Chicago and across the country, but happy to answer if there's a follow-up question.
I'll provide instead of that another question from the audience. Jennifer Burrows, who I think is over here, a City Club member. We see some businesses beginning to engage in political positions, i.e. 145 CEOs recently signed a letter regarding reasonable gun rights. Is there a role that business leaders can play to promote individual rights for women, minorities, and the LGBT community, for example?
Yes, and thank you for that question. I'm going to say that perhaps business leaders have long played a role on public policy and political issues. What is, I think, remarkable about the ad that ran, or the letter that ran, of 145 CEOs of major American companies, was they were so public about it. And this device of using a letter that's then published or republished in the Washington Post, the New York Times, the Chicago Tribune, on the part of executives, is actually a device or tool that we've been using with increased frequency in a range of our advocacy. Right after the state of Georgia passed its near ban on abortion rights, something like 120 CEOs of major American companies signed a letter expressing their concern about the impact of that legislation on women's rights. Likewise, in the fight a few years ago to win the freedom to marry here in Illinois, business leaders were among our more relentless allies in the legislative process and in, really, quite frankly, the form of public opinion. People talked about how hard it would be to continue to attract top talent if the state of Illinois did not amend its marriage laws to permit the freedom of marriage of all people to marry the people that they love. And so I think that this is a really important strategy. I think it's, a slice of what I meant by,
the advocacy, the defense of our Constitution is ultimately invested in we the people, and I would include corporate leadership in that, and we would welcome their joining the fight, or continuing to join the fight, to be more precise.
Any more questions? No? Okay, well, we have a round of applause for a really wonderful and thought-provoking conversation.